Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of conflict or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as your law intellect. As you come in, if you could be so kind as to hit that like button, subscribe to the channel if you have not done so already. We are here to give another update on the Tory Lanez, Megan Pete, Milagro Grams. It's been going on for a while. And as you all know, I was just in Miami a month ago because Megan Pete sued Milagro Grams, who is an online commentator, for defamation, um, a, a deep fake video, and for intentional infliction of emotional distress. And so, one of the things that I told you all is that there were still some issues that were probably going to carry on beyond the verdict. And slowly, we've seen different things that have happened in this case. So, for example, many of you may know if you follow the platform that Tory Lanez, there was a deposition, and in that deposition, he was uncooperative, and I'm being kind. And so he and his lawyer were sanctioned by the court. So his lawyer has actually appealed that court's decision to sanction her. So that was something that happened, I think it was earlier this week that notice of appeal was filed. Last week there was another lawyer that entered the team on Megan Thee Stallion. So we pretty much knew that it wasn't over, that it was just getting started. And so today there was a motion filed for a permanent injunction against Milagro Grams. And that is what we are going to go over tonight. So thank y'all so much for coming in, supporting the platform. Pray then hustle. You said thanks for keeping us informed. Thank you so much for supporting and for coming on over here to hear what we got to say. At Darlene Burrell 3165. Thank you so much for the super chat. You said supporting the channel. I appreciate the support. So let's get right into it because we don't have time to tarry. Let's see. So what has been filed is excuse me, plaintiff Megan Pete's motion for entry of permanent injunction against cyber stalking pursuant to section 7840485 Florida statutes. And so here's a preliminary statement. What I'm going to do is I'm not going to read the entire 23 pages because a lot of this stuff is redundant. We know about all of the allegations for the most part. We know about what occurred with the Tory Lanez, Megan Thee Stallion, and what Tory Lanez is in prison for currently. And a lot of that information is, of course, placed in this motion to give a complete background before they get into their request. But let's read the preliminary statement so we can know exactly what Megan Pete is asking. Plaintiff Megan Pete hereby moves pursuant to Federal Rules of Civil Procedure 65 and Section 7840485 Florida statute for the entry of a permanent injunction against defendant Milagro Cooper. Hold on one second. Defendant's retaliatory cyber stalking campaign has caused substantial emotional distress to Ms. Pete and put her in reasonable fear for her physical safety and health. A permanent injunction against cyber stalking is warranted in light of defendants' repeated attempts to interfere with the administration of justice in relation to Ms. Pete's reporting of and proceedings arising from a violent assault on Ms. Pete. Defendants' willingness to retaliate against those who engage in essential speech related to the reporting of crimes and torturous conduct, and defendants continue harassing conduct since the verdict in this case, which demonstrates that she lacks respect for the rule of law and that only injunctive relief will be effective in this context where defendant otherwise claims to be judgment proof. An injunction is essential to protect Ms. Pete against the threat of harm posed to her safety and well-being by defendant's conduct and would be consistent with the jury's finding of defamation per se, intentional infliction of emotional distress, and promotion of an altered sexual depiction in violation of Section 836.13 Florida statute. An injunction is further warranted because the conduct engaged in by defendant serves no legitimate purpose. As such, forms of cyber stalking and victim and witness retaliation are barred under the state and federal criminal laws. Ms. Pete will continue to suffer irreparable harm if defendant is permitted to further stalk, bully, and harass Ms. Pete and to further incite defendant's, quote, mob of followers who has been primed over the last 5 years with hateful rhetoric directed at Ms. Pete. There is no legitimate purpose to defendant's speech. It is wholly unprotected and indeed encroaches on state and federal criminal statutory bars, due not only to the underlying cyberstalking conduct, but also to the obstructive and retaliatory conduct that has sought to punish Ms. Pete and anyone who supports her as a victim and witness. In support of this motion, Ms. Pete relies on and incorporates the testimony of record, all admitted trial exhibits, and Ms. Pete's previously filed petition for an injunction against cyberstalking. Ms. Pete respectfully requests a narrowly tailored permanent injunction as set forth in the attached proposed order. So this is an issue that was raised before related to an injunction because that is something that could have been requested, and the court held off until after the verdict. So this is another post-verdict issue that they wanted to be addressed by the court. As you come in, make sure you hit the like button. We're on the ground running now. So they get into the factual background, and they start off again. I'm not going to go through all of that. Defendant coordinates with convicted felon Daystar Peterson to harass Ms. Pete. So they go over all of that. So then they go into the evidence at trial leads the jury to render a complete verdict against defendant based on her harassment of Ms. Pete. 1, defendant causes Ms. Pete severe emotional distress and fosters a community directed at harassment. After a 9-day trial before this court, the jury expressly found that defendant falsely accused Ms. Pete of the crime of perjury, a felony, by lying under oath. Due to defendant's defamatory statements, Ms. Pete testified about how people began seeing her, quote, as somebody that would lie and say she was shot for no reason just to see somebody suffer, end quote. And they're quoting from the trial transcript. The purpose of these false allegations was wholly retaliatory following Ms. Pete's complaint and testimony against Mr. Peterson. Defendant has long weaponized social media to intimidate, bully, and incite violence against Ms. Pete by continuously posting and streaming about Ms. Pete to her audience, which included not just her social media followers, but also expanded to followers of anyone who liked, commented on, or reposted her statements. Prior to this civil trial, the court entered an order governing pretrial publicity on June 10, 2025, in part to prevent defendant from continuing to spread misinformation about Ms. P and her case against defendant. In issuing the order governing pretrial publicity, Judge Reed considered defendant's harassment of a deponent and future trial witnesses, Emil Holland Briggs. And it has, quote, defendant has gone after a deponent in this case. He testified, gave us very important information that goes to whether the defendant knew her statements about Ms. Pete were false. She's attempting to intimidate him and say horrible things about him in her social media posts using pretty vile language, frankly, that I'm not going to repeat. So that is a part of a transcript from May 24th, 2025. And then they have, I guess, it's a deleted X post that says, this ninja Holland Briggs just wants to hurt me. It's a shame he's wasting the court's time with complete lies. Never. So that's supposed to be what the post was. This obstructive conduct during the instant case highlights defendant's flagrant disrespect for the justice system and the courts. This harassment and cyberstalking resulted from defendants colluding with Ms. Pete's assailant to retaliate against Ms. Pete and to perpetuate a false narrative regarding the criminal assault on Ms. Pete. This was accomplished by defendant intentionally spreading lies and material falsehoods and her repeatedly attempting to undermine and discredit Ms. Pete's truthful allegations of a violent and horrific assault. And they got all these different quotes. This collusion between defendant and Mr. Peterson, the man who shot Ms. Pete, interfered with Ms. Pete's livelihood, traumatized Ms. Pete, and caused her severe emotional distress. And they're quoting from Dr. Lenore Walker and what she said at trial. The severe emotional distress that Ms. Pete suffered at the hands of the defendant also impacted her livelihood and her personal and professional relationships, even costing her business deals. And that is from Daniel Kinney. He was the individual that worked for Roc Nation. The message throughout the entire cyberstalking campaign was clear: to retaliate against Ms. Pete for reporting Mr. Peterson's crimes to law enforcement. Indeed, defendant's promotion of Mr. Peterson's Cap music video, in which Mr. Peterson severs a horse's leg with a bloody butcher knife, reflects her trivialization of Ms. Pete's harm. And they have that exhibit that they showed a few times at trial. Moreover, defendant's post demonstrates her ability to stoke hate and harassment against Ms. Pete among her followers and vast audience, whom she refers to as her mob. Defendant clearly and unequivocally on repeated occasions threatened to and did turn this, quote, mob on Ms. Pete for no reason other than that Ms. Pete has sought to ensure that her violent assailant was held accountable and brought to justice. At trial, Ms. Pete testified about how defendant's posts making light of violent scenes from the music video created a space for people to laugh and joke about threats made to her life. So you have quotes from the transcript again. The bloodied horse's leg served as a crude and threatening metaphor for what defendant and Mr. Peterson were willing to do to Ms. Pete as a result of her speaking up as a victim of a violent crime. Defendant is aware of the influence she wields. So another trial transcript where they say defendant's June 9, 2024 live stream where she says, quote, but I'm too influential now is what I've come to realize, end quote. Defendant amassed this influence by building a social media and streaming business targeting Ms. Pete. See Megan Pete's transcript where she says, quote, she is famous because of talking about Megan Thee Stallion in the Tory Lanez case. She got famous and known for trashing me. That was part of Megan's testimony at trial. Defendant acknowledged that she had been speaking about Ms. Pete on her platform for the past 5 years, allegedly due to, quote, new developments, new documents, new tips, knew this, knew that caused it to be an ongoing conversation, an ongoing point of interest for the public. So that's from Milagro's testimony. and operating numerous social media platforms, including YouTube, Instagram, Twitter, Kick, and Stationhead, quote, at least 5 days a week. Defendant's statements have spread far and wide. And so they have different transcript quotes. One of them is her statements have incited further hate and threats against Ms. Pete, especially among her, quote, cult-like following. That's from Mill Holland Briggs. Remember, that was her former moderator. Defendant's conduct had a lasting impact on Ms. Pete's mental and emotional well-being, thereby further interfering with her livelihood. At trial, Ms. Pete testified about how years of harassment left her feeling tired of being alive. So they're quoting those different quotes from the transcripts when she said, "I just wanted to die." Her manager, Travis Ferris, also testified about the length and severity of defendant's cyber stalking, nonstop for 5 years, and so egregious that defendant could find herself in, quote, the Guinness Book of World Records of hating, end quote. And that is from Travis Ferris. In the face of this overwhelming evidence of the severe emotional distress suffered by Ms. Pete, the jury found defendant liable for intentionally inflicting emotional distress. The second is defendant's harassment of Ms. Pete include lies about her mental state, family, and alcohol consumption. Defendant's harassment campaign has not been limited to statements and conduct concerning the shooting. Rather, the retaliatory harassment is broad and far-reaching. Defendant has spewed spiteful and derogatory comments about Ms. Pete, including making unfounded accusations regarding Ms. Pete's mental capacity and alcohol consumption. So they have a lot of quotes from the transcript. Defendant's incessantly false and hateful speech, which enjoys no First Amendment protection, extends to Ms. Pete's family. Defendant has falsely reported to her wide audience, the mob, that Ms. Pete's parents and grandparents were criminal thieves and drug addicts. So they quote Megan Pete's testimony on that. Now, the third one is defendant promotes a deepfake pornographic video of Ms. Pete. Defendant's disturbing fixation on retaliating against Ms. Pete is perhaps best reflected in her willful and malicious promotion, as found by the jury, of the deepfake pornographic video, which was distributed without Ms. Pete's consent and with knowledge that the video did not depict real events. And so they quoting when Milagro said, "Go to my likes." On June 8, 2024, the ex-post admitting that she directed individuals to the deepfake video, quote, so that people could see the video another ex-user posted. Defendant's June 8, 2024 live stream that the video, quote, has got to be AI because I know this BITCH is not this dumb, end quote. These are all exhibits that came in at the trial. Defendant June 8, 2024 live stream saying, quote, be mad that I drew attention to it, end quote. Another exhibit, defendant's June 8, 2024 live stream stating, I put the video on my MFing Discord and tweet about it. Another exhibit, defendant June 8, 2024 X post, and that's not illegal. Suck it. Another June 8, 2024 was an exhibit, live stream. Y'all go to my likes. This is a fool. Watch how this post jump. Then they got another live stream. Another one from defendant's June 9, 2024 live stream claiming she, quote, don't understand what the F Miss Pete is crying for after she promoted the deepfake video. As would anyone, Miss Pete suffered extreme embarrassment, trauma, and distress about discovering the deepfake video and defendant's promotion and implication of it. So then they're quoting the trial transcript from Megan, who says, I felt icky. I felt shame. I felt like my grandma that is still alive. This was just something else that I knew that she was going to ask me about. Like, is this real? You know what's going on? I just felt really embarrassed. They quoted from Travis Ferris, who said, she cried, she shut me out the room. She went in her room and just cried, didn't come out for, a few hours. And hearing defendants' live streams regarding the deepfake, Ms. P felt defeated and powerless to do anything because, notwithstanding the artificial nature of the pornographic video, she believed that defendant and her followers, quote, wanted it to be real. So that's from Meg's testimony. Then they go to point 4. Defendant stalked Ms. Pete's residence online. Defendant also has access to and knowledge of Ms. Pete's residential address. Specifically, defendant saved at least 2 screenshots of Ms. Pete's personal residence on her phone, which she admitted to at trial. So they got the transcript where she acknowledged how she came about getting these images and that they were in her home and that it was a screenshot of Ms. Pete's residence. Notwithstanding defendant's alleged reason for possessing Ms. Pete's sensitive personal information, defendant did not dispute that she searched for, took screenshots of, and shared said information with her former attorney. Ms. P has expressed serious concerns for her safety in light of defendant's cyberstalking history, corroborated by the testimony of Emil Holland Briggs, her former content moderator. In the trial transcript, it said, quote, defendant was paying sites to pull these people's information, I believe like their home addresses. She would go into their background and she would use that as ammo against them. Quote, when I found out that she had a picture of my house, so this is the quote from Megan's trial transcript. When I found out that she had a picture of my house in her phone, I feel like, oh my God, this is a dangerous person. I'm thinking, what are you? Why do you know where I live? What are you going to do to me? Like, are you going to come to my house? It just confirmed I don't know what this stalker is going to do with my address. Then another quote from Megan Pete from the trial transcript. I do think Milagro is dangerous because I don't know why she would have my address or my house saved in her phone. Indeed, at trial, Ms. Pete testified that the purpose of the lawsuit was to stop defendant from continuing to harass and bully her. You think you can team up with a man to continue to harass and bully me online just because I don't even know what's the reason, but I want her to stop. Ms. Pete's testimony underscores the harm that she has suffered on account of defendant's harassment and cyberstalking. As the trial record reflects, defendant's social media is rife with threatening commentary against Ms. Pete, and they give examples. Defendant's March 12, 2022 ex-post mocking violence against Ms. Pete depicted in the Cap music video. Defendant's December 19, 2022 live stream that says, a bitch F with my ninja Tory. I'ma slap that hoe, Miss Pete, and whatever come after it, come after it. Defendant's July 30th, 2024 live stream said, quote, you better get that bitch away from me before I run that hoe over with this MFing car. So that is the background. Have you guys hit that like button before we get into what they're saying is still happening right now? Miss HLS said that's very weird. Okay. Jam said these people are weird. Jean said only miserable people agree with Milagro's actions. What if that mess was being done to their child? Yeah, y'all got to hit these goals now. Dale said, if you're going to run your mouth, make sure you can afford an attorney. Rabbit the realtor said, think of it like this, that mill lady still got to spend money on lawyers, so she is paying one way or the other. Yes, this is stuff that happened at trial. So, and then they're going to get into, so what happened is the court reserved, I guess, whether they would do a permanent or some type of injunction, or if an injunction was even necessary, because there's a strong, I guess, presumption against trying to restrain someone's speech. And so because of that, the court wants to make sure that there's no other remedies that can be fashioned to stop whatever is happening. and the court held off on it. And it looks like Megan's team held off for a minute to see what was going to happen after this. Were there going to be still conversations? Was she still going to talk about it? And I think it's interesting. What was it yesterday? I think the interview with Tasha K came out, and then today they filed this. They did do an interview, I want to say on CBS or with one of the local stations as well. So yeah, it looks like they just waited to see what else they can try to add to it. All right, so let's go on. Thank you so much, Miss HLS. That is very weird to have her house and her phone. She said she thought there would be some jurisdictional discussions on whether Florida was the proper state. And so because she didn't have any money, she had to do some of the grunt work for her attorney, is what she said, while she had her screenshots of her phone. Her moderator testified that this is what she did. Like, she would do background checks on people. Like, it was some site where she can get information about people. That's what her moderator, Emil, her former moderator, testified to. Thank you, Shirley, for the super sticker. I appreciate it. Hey, Queen Shadina. Thank you so much for the super chat. All right, let's get into what they're alleging is still happening now. Defendant's harassment continues even after the jury found her liable on all 3 counts. Defendant has been wholly undeterred by the recent verdict in this matter. This is perhaps unsurprising, given the record evidence demonstrating defendant's lack of respect for the justice system. It has only been 2 weeks since the jury entered a verdict in Ms. Pete's favor, and this court lifted its pretrial publicity gag order, and defendant has already returned to social media to resume her campaign by posting yet more disparaging comments directed at Ms. Pete. On December 1st, defendant went on Instagram Live showing no remorse for her conduct and claiming, quote, "I'm going to start working on my mixtape," because apparently the only place you can bully people and talk crazy and pop-ish is in the studio. But anywhere else is off limits, you know? So I'm going to get on my mixtape-ish and make sure I channel all my energy into my raps and put that out and let that be artistic expression. So then they got the link over to the Instagram at the bottom. Defendant stated intent to use the First Amendment shield of, quote, artistic expression as a sword to cause further harm to Ms. Pete, reveals that she views the jury's verdict as a minor inconvenience, not a true deterrent. Defendant also mocked Ms. Pete's emotional distress on this Instagram Live. When a social media user commented that defendant had lost the lawsuit, she responded, quote, "I heard you blocked too. Listen, all I'm ever gonna do is block y'all. I don't get on the internet and cry about what y'all say," end quote. On December 2nd, defendant posted images of herself on X with a promotional photograph of CBS News reporter Gayle King, which members of her audience would reasonably interpret to be a reference to Ms. Pete. See Appendix C. A reasonable viewer reading defendant's December 2nd post would understand her Gayle King photograph to reference Ms. Pete's interview with Ms. King many years ago, which defendant unsuccessfully relied on at trial to suggest Ms. Pete lied about her interactions with Mr. Peterson. Defendant later went on air with CBS News Miami and demonstrated a lack of willingness to take accountability for promoting the deepfake video. When asked why she promoted the video, defendant responded, quote, "I think that's a tricky question because I think there are misconceptions about what actually happened. I did say go to my likes and I did speak about it," end quote. Furthermore, when asked whether she considered the harm of the deepfake video on Ms. Pete, defendant stated, quote, "Did I personally think that this would cause her to feel those ways? Absolutely not," end quote. On December 3rd, defendant took to X once more to continue to spread misinformation about Ms. Pete, misleading her followers and lying about the jury verdict. See Appendix D. Defendant wrote that, quote, anything that had to do with mental capacity or alcoholism never even made it to the final sheet, end quote, disregarding the jury's findings that defendant was liable for IIED based on her statements attacking Ms. Pete's mental capacity and recreational alcohol use. And it reveals that notwithstanding the jury's verdict with respect to those statements, defendant intends to double down and continue to perpetrate or perpetuate defamatory falsehoods about Ms. Pete. Defendant also wrote that the 3 defamatory statements for which the jury found her liable were not, quote, statements of fact, end quote, even though the court previously determined that they were. The message of this post was clear. Defendant unequivocally denied the jury's finding and suggested to her, quote, mob of followers that prior statements about mental capacity and alcoholism were in fact true when she knew full and well that they were false and defamatory. Defendant was not the only one levying attacks against Ms. Pete and misrepresenting the verdict. Shortly after the court dismissed the jury, defendant's counsel issued a press release falsely claiming that defendant was found, quote, not liable for defamation, Appendix C. Plaintiff's counsel privately raised concerns with such misstatements on this press release and asked for a retraction. Defendant's counsel instead posted the private email exchange on social media, subjecting plaintiff's counsel to undue harassment and doxing by defendant's followers. See Appendix F. Defendant and her counsel cast what actually occurred in court in false light. As the verdict form plainly states, the jury found defendant liable on count 1, defamation per se. That the court only entered judgment on counts 2 and 3 has no bearing on the jury's ultimate determination that defendant was liable for count 1, defamation. As recently as December 15th, defendant went on another blogger's live stream and made various accusations against Ms. Pete and other trial witnesses. She accused Emil Holland Briggs of committing perjury, claiming, quote, and I have now, been betrayed in the worst way. Somebody I used to be friends with, old child, got up on the damn stand against me, lied on me in federal court. The defendant also alleged that Miss Pete made herself out to be, quote, the Black Regina George, who in the film Mean Girls was a bully, end quote. And she attempted to shift blame to Miss Pete's manager, Travis Ferris, stating that he, quote, should have been up there, end quote, for intentionally inflicting emotional distress because he showed Miss Pete several of defendant's harassing social media posts. Throughout the live stream, defendant downplayed her defamatory statements as mere questions, undermining the defamatory and severe emotional impact of her post on Miss Pete. This was just the latest example of defendant's harassment against Ms. Pete. Absent an injunction, defendant's gamesmanship will not stop. Through crowdfunding efforts designed to wholly offset the jury's damages award, defendant has eschewed the consequences of her actions. As her crowdfunding page shows, defendant will continue to characterize her defamatory and tortuous conduct online as rooted in the, quote, right to speak, right to question, and right to know. Appendix G, the jury's findings should not be disregarded in this manner. So at the bottom, they have links. One of the footnotes says, I'm not out of the airport yet, but I did just get word that the judge did sign on the dotted line. So the order is official. Defamation was thrown out. She recognized me and agreed with the jury that I am media. So I'm going to need all of y'all to correct them different things that y'all then put on online. Okay, love you. That was December 2nd. Another one in the footnote is defamation is a wash. And then they have the link for Tasha K, Surviving Megan Thee Stallion, the voice of new media. So those are the links they got at the bottom. Let me put up some of these appendixes that they talked about. Let's see. So this was the original petition for an injunction. The undersigned, so they have that. Let me see. And that was February 10th of 2025. So there was an origination of an injunction petition. And then, let me see. The ex post was Appendix B, which has Milagro. I guess her name is at New Media now. And it says, this ninja just wants to hurt me. It's a shame he's wasting the court's time with complete lies. And then I guess all the people that had something to say about the post. It's very weird. So this was back in May, it looks like. Somebody said it's very weird. They keep saying Peterson said Meg merely stepped on glass when that was Meg's lie to begin with. LOL. Tired of black people. They contradict their own standpoint because all of Sean Kelly's testimony and statements and interviews were all placing the women outside the car, not in it. And the ballistic expert said nothing was fired inside the car. They're scrambling. That's right. Get them. Love it. So they just basically, all of the comments people had to say, look, they got the picture. They are really clowns for this. They got the picture of the horse. Yep. So that is that. Let me see. Appendix. Let's see what C is. C is get to work, honey, even spotted Gail. So I guess this is the Gail King reference from December 2nd. So there's that. And then all the comments from people. They made sure that they're going to allow the court to see that. Let's see. D. This is from X. To be clear, the defamatory statements were in relation to questioning honesty. Which would have been challenged anyway, because none of the three comments used against me were a statement of fact, meaning the ish y'all say and ask on here could land you in the courtroom if we went by that standard. Anything that had to do with mental capacity or alcoholism never even made it to the final sheet. So I know it's hard for people who only read headlines to understand, but the Dream Team did a phenomenal job. So that was another post that they talked about, they being Megan's team. This was the press release that was from Jeremy, where it said, while many outlets are reporting that Ms. Cooper was found liable for defamation, the final judgment of the court is that Ms. Cooper is not liable for defamation. Ms. Cooper ultimately prevailed on Ms. Pete's leading accusation, defamation, and the jury awarded nominal amount of damages compared to millions of dollars Ms. Pete demanded from Ms. Cooper throughout the course of the litigation. So this is what the issue is with this statement that Megan's team was trying to point out. Milagro was found liable for all three counts. What happened is there was an issue on whether she was considered media. Media is already defined in Florida. It wasn't no defining it. It was already a definition, but it was whether she fits that definition based on what she does as an online commentator. It could have always included bloggers and everybody else if you fit these certain terms of which they declare you as media. And so the court allowed the jury to decide whether she was media. So there was a bunch of questions that was very confusing. And the last question is, do you consider her media? And the jury said yes. Even though, interestingly, I don't think they answer yes to all of the separate questions, so I didn't understand the purpose of it, because it seems like you would have to answer yes to everything, but I guess that's something they'll figure out. But nonetheless, the ultimate question was, do you consider her media? And the answer was yes. Because of that, Milagro should have gotten notice of, similar to like a cease and desist, similar to it. I'm not going to say it's exactly like it, but tells you you're violating this law. These are the defamatory statements, da 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 da, and give you notice. I think it's 5 days before you file. They automatically, I guess, consider that maybe she wasn't media, or that maybe they didn't even know that they had to do that before they filed. Whatever the reason is, they did not treat her as media. So, because they didn't give the notice, that means that that claim for defamation can be dismissed. So, it wasn't that the jury did not find her liable. They found her liable. So, when people said that, it was the truth. It's just the final judgment is not going to have it on there because the jury says she's media, and that means there should have been a procedural hurdle that should have been overcome first, which they didn't do. And so now that entire claim gets dropped. So I'm sure they'll probably define that what they're saying in this press release is saying what I said or something similar to it. But this is why them saying like she was found liable, them saying that the final judgment of the court is that Miss Cooper is not liable for defamation and that she ultimately prevailed on the leading accusation, it can be interpreted as if she really was not found liable. So I think that's what Megan's team was trying to relay. So then the press release goes on to say juries are called to make difficult decisions on complicated questions of law and fact. While we do not agree completely with the jury's verdict, we respect its verdict and we thank the jury for giving us their time and attention for more than 2 weeks. Ms. Pete and her attorneys asked the jury to send a message to the community by awarding Ms. Pete with an astronomical amount of damages. Indeed, the jury rejected Ms. Pete's request and refused to send any such messages as shown by the nominal damages Miss Pete recovered. Now, I view nominal damages as $1, $100. I don't know if I view nominal damages as $8,000, $10,000. Nominal is usually just that, but I guess compared to millions that you're asking for, is it a lot smaller than what they were asking for? Absolutely, it was. Evidently, the jury did not believe that Miss Cooper was the sole cause of Miss Pete's emotional distress, and that is reflected in their verdict. The jury's verdict also reminds us all that you cannot sue media defendants without providing the proper due process. We remain proud of the defense we presented and of Ms. Cooper's willingness to stand up for her voice. The broader questions about protecting online speech, defining the boundary between opinion and defamation, and safeguarding independent creators will continue to be critically important. Ms. Cooper claims her rightful position as a new media commentator, talk show host, and personality. So that's why I said the way people were like defining, talking about this news media like it was some old new phenomenon that just happened was like, did y'all like not read what was really going on? But hey, I digress. So then the last, hold on, Appendix F. So I guess this is what was posted. So then this is from Milagro's team when they said that his attorney ended up posting the information about what they sent him, trying to tell him to retract him saying that she was not found liable. So they said, after we released our official statement yesterday, Quinn Emanuel, Megan's attorneys, emailed Jeremy in an attempt to intimidate and threaten the defense team to retract his statement. Quinn Emanuel continued by releasing his own statement, falsely accusing the defense of making false and defamatory statements. Some, but not all, of the independent journalists who were present during the trial aligned themselves with Megan's attorneys and promoted the false narrative that the defense team was somehow lying about the results of the trial. Megan herself took to Twitter and accused the defense team of lying. hours ago, Judge Altanega reduced her oral ruling to writing, and it is clear that I think it's they didn't finish that. So apparently, this was the statement, that the email that was sent. Jeremy, your press release has come to our attention. As you are aware, your statement is categorically and demonstrably false. Your press release falsely claims Ms. Cooper prevailed and is not liable for defamation, when in fact the jury found her liable on all counts, including defamation. This is a material misrepresentation of the jury's verdict and the court proceedings. As you know, the court has not entered any kind of judgment. The jury found your client liable on every single count. Even if the court entered judgment today, it would not say not liable on count one. You and your client are posting defamatory content, and we demand a formal retraction given your statement has already been spread across social media. Confirm you will retract immediately. If you do not retract immediately, we plan to bring this to the court's attention and reserve our rights against you, your firm, and your client. Regards. So there is that. Those are the appendixes, the exhibits that were mentioned as I was reading. And so to get back to the motion real quick, hold on, let me see what some of you guys are saying. Oh gosh, I know this is a very, very touchy subject, and people like to just really go at it up in the chat when it comes to this. I don't understand why people take this so personal and deep. Yeah, it's a pre-suit notice. That's what it was, and it's kind of being. And again, like I said, the media definition didn't change. It was literally, if you fit under these categories, you give unbiased commentary. You're not trying to support one person over the other. You're not trying to promote yourself and your services and what you do. And that's all you like. It was literally just questions that if you fit under it, then you're considered media, whatever that definition is. And it's always included. It was all encompassing. It wasn't just for if you were a journalist and went to school. It was literally the whole big umbrella of media. So if you fit up under media, regardless of what your position is, and you fit under that definition, then they're supposed to give you some type of pre-suit notice, which I was actually shocked that they didn't even just at minimum send a cease and desist. I'm like, if she had been doing this according to you since 2022 and you've been keeping record of this, why would you wait all this time to like just send her a lawsuit? But hey. There's that. Okay, I didn't see that I missed anything on here. Let me see. I got all the super chats. So then they get into the legal the standard. So this is the statute, section 784.0485 sub 1. Florida statutes creates a cause of action for an injunction for protection against stalking, and states that, quote, for the purpose of injunctions for protection against stalking under this section, the offense of stalking shall include the offense of cyber stalking. The stalking statute specifically allows trial courts to grant such relief as the court deems proper when issuing a permanent stalking injunction. In federal court, a plaintiff seeking an injunctive relief must demonstrate: 1, plaintiff has suffered an irreparable injury; 2, remedies available at law, such as monetary damages, are inadequate to compensate for that injury; 3, considering the balance of hardships between the plaintiff and defendant, a remedy in equity is warranted; and 4, the public interest would not be disturbed by a permanent injunction. So what they're going to do now is they're going to apply all of the facts to each of these prongs to show that they're all satisfied. So they're saying all factors weigh in favor of entering a permanent stalking injunction that restrains defendant from harassing and cyber stalking Miss Pete through her persistent and egregious online activity. Defendant's relentless campaign to defame Miss Pete and to destroy her public image, and livelihood serves no legitimate purpose, but rather an illicit one, to retaliate against Miss Pete for her cooperation with law enforcement in the prosecution of her assailant. The sole and apparent aim of this aggressive cyber stalking campaign, as the evidence at trial revealed, was to punish Miss Pete for none other than her status as a shooting victim of someone who happened to be close friends with the defendant. So, as it pertains to the first element, it says Miss Pete established the requisite elements of cyber stalking and harassment under Florida statute. So they say one, defendant engaged in a pattern of cyber stalking directed at Miss Pete. And so they go over all the trial evidence that they're alleging shows that. Two, defendant cyber stalking caused Miss Pete substantial emotional distress. Three, defendant cyber stalking has no legitimate purpose. And then they got sub B, Miss Pete is entitled to a permanent injunction pursuant to Federal Rules of Civil Procedure 65. Miss Pete also meets the elements for a permanent injunction pursuant to the rules. As a preliminary matter, Ms. Pete has already established a requisite element of success on the merits. A jury considered Ms. Pete's evidence and found defendant liable for defamation per se, IIED, and promotion of an altered sexual depiction. Number one, Ms. Pete faces irreparable harm from defendant's ongoing conduct. First, defendant's cyberstalking conduct that has yet to cease following a 2-week trial and jury verdict has and will continue to cause Ms. Pete irreparable emotional and financial harm absent any action by the court. Psychological injury can constitute irreparable harm that warrants injunctive relief. So they got a bunch of case law to support that statement. Ms. Pete's past and continuing injuries were proven at trial via Ms. Pete's Mr. Kinney, Mr. Ferris, and Dr. Walker's testimony. Ms. Pete herself testified for hours about the extreme emotional impact of defendant cyber stalking. Dr. Walker emphasized that if Ms. Pete is continued to be triggered by online posts from defendant, she may never recover from the trauma of the shooting. Furthermore, Ms. Pete proved at trial that she suffered reputational harm as a result of defendant cyber stalking. She lost at least 4 major brand deals due to the emotional distress suffered at the hands of defendant. Plaintiff has endured more than enough suffering to prove irreparable harm will ensue absent a permanent injunction. Then they say, secondly, defendant has already proven that money damages are an inadequate remedy. There is no adequate legal remedy for defendant's continued conduct. And so they got the law. Monetary damages and sanctions imposed against her clearly have not deterred defendant, and they will not adequately compensate Ms. Pete for the severe emotional distress and reputational harm she has and will continue to suffer. Point 3, the balance of equities in the public interest favor injunctive relief for Ms. Pete. The balance of equities tip in favor of Ms. Pete. Defendant would not suffer any harm from a narrowly tailored permanent injunction. She has already found liable by a jury for engaging in unlawful conduct. Ms. Pete faces significant emotional and reputational harm if defendant continues to cyber stalk and harass her. This harm was evidenced through testimony during trial, including Ms. Pete's testimony as to the potential consequences of defendant's conduct. Furthermore, the public has no interest in defendant's illegal cyber stalking of Ms. Pete. Indeed, it is in the public's interest to prevent harassment and stalking of all individuals to ensure others do not experience the harm suffered by Ms. Pete. An injunction against defamation is also warranted under Florida law. Florida appellate courts have recognized that injunctive relief against defamation is appropriate where defamatory statements are made as a part and parcel of a course of conduct deliberately carried on to further a fraudulent or other unlawful purpose. Given the jury's factual findings of defamation and the intersection of the defamatory statements with the torturous cyber stalking and obstructive retaliatory conduct, as well as the interference of such statements with Ms. Pete's business interests, equitable relief is appropriate here. Defamatory words uttered in aid of another tort are verbal acts which, with the aided tort, are subject to restraint if equitable grounds, therefore, are present. The defamatory statements here not only aided cyberstalking, obstruction, and witness retaliation, such statements also caused substantial harm to Ms. Pete's business interests. An injunction against defamation is thus appropriate here. This court's finding regarding the entry of judgment on the defamation count does not change Ms. Pete's entitlement to equitable relief because Ms. Pete has established actual success on the merits. The legal test for injunctive relief makes clear that the established facts matter, not the question of whether judgment was ultimately entered. The jury's verdict on the defamation count serves to establish actual success on the merit as required by law. So then they say Ms. Pete's proposed injunction complies with the statute and the Constitution. Ms. Pete's proposed injunction submitted herein is narrowly tailored to protect defendants' First Amendment rights while also targeting specific statements for which a jury already found defendant liable and for which defendant has no intention of stopping absent an injunction. This is some boring mess, my gosh. Okay, let me oh, do I write like this, Dev? No, I'm like, gosh, I am sorry, y'all. I'm trying to get through it. This is terrible, right? In my opinion. I don't like this writing at all. All right, let me see what this. You said it's whack. I'm like, do I be boring people like this with my writings? That's what kept coming through my head right now. So let me show you the proposed order that they're trying to. I gotta take a nap after this. I'm sorry, y'all. I had to bore y'all like this, but jeez, Pete. All right, this is the proposed order. Did I put it? This cause came to be heard on plaintiff Megan P. This is proposed. This is what they want the court to enter. This cause came to be heard on plaintiff Megan Pete's motion for entry of permanent cyberstalking injunction against defendant Milagro Cooper, the defendant, pursuant to section 784.0485 Florida statute. The motion, the court, having reviewed the motion and being fully advised as to the premise, finds as follows. Plaintiff has established that she is the victim of cyberstalking by defendant pursuant to the law, and that she has been defamed by defendant. A permanent injunction is warranted for the reasons stated in the motion. It is therefore ordered in the judge the request for a permanent injunction is granted pursuant to the law and the federal rules of civil procedures. The court hereby enters the following. So this is what they are actually requesting. Again, this has just been filed. So of course the other side is going to respond and oppose it. Ultimately, the judge is going to make the decision, but this is the proposed order of what Megan P. is requesting the court to sign. Injunction restraining defendant as follows. Defendant shall not have any direct, indirect, or third-person contact with plaintiff, including but not limited to written, telephonic, electronic, and social media contact for a period of 5 years. Defendant shall remain at least 500 feet from the plaintiff, her residence, and or any other place plaintiff is or is anticipated to be, and shall remain 1,000 feet from plaintiff's musical performances for a period of 5 years. So she can't go to no Megan Thee Stallion concerts. That's what they want. Defendant shall not publicly disclose plaintiff's private personal identifying information, including her residential address, phone numbers, and other contact information. Defendant shall not further promote, distribute, share, or otherwise transmit the deepfake video for which defendant was found liable of promoting or any other altered sexual depictions of plaintiff. Defendant shall not make further defamatory statements about plaintiff on the internet or in other public forums regarding plaintiffs. Testimony at Daystar Peterson's criminal trial, including the circumstances and causes that gave rise to plaintiff's injuries, mental and emotional state, recreational use of alcohol, and extended family. A defendant shall not make any communications about plaintiff that are intended to incite third parties to engage in threats or violence against plaintiff, her professional team, and or her family. Defendant shall not harass, strike, threaten, assault, hit, follow, stalk, cyberstalk, disturb the peace of, annoy by phone or other electronic means, including through repeated contact or impersonate on the internet, electronically, or otherwise plaintiff. And defendant shall remove from the internet and related public forums all statements and postings that form the basis for the jury's verdict in this case. So that is what they are requesting. So what do you all think? I know that was a lot and it was boring. I'm sorry. But this is the information I have. I have to give you all the follow-up. I have to. T. Collins said, y'all want people to give Millie grace, but none was given to Megan. What? I hope Trump sue everyone who ever talks about him. Well, he's going to stay in court, right? Okay. All right, that's it. Unless y'all got something else to say. Unless y'all got something else to say. D. Joyce said, wishing Megan peace. I don't know if it's safe to drop the link, so I'm just going to thank y'all for coming in. Make sure you hit the like button. Subscribe to the channel. My sister said no. Y'all tripping out here. Yeah, that Dev shook his head no when I said it. My sister got in here and said, hell no. Y'all tripping. I need you guys to behave while I'm reading. All right? Because I'm not paying attention to the chat. Thank y'all so much. And yeah, I'll see y'all something else drops and goes down. Thank you so much, Sassy, for becoming a member. I appreciate you. And yeah, we out of here because apparently you guys do not know how to act. All right, I'll talk to y'all later.